Welcome to the joint. Good afternoon. Welcome to the joint veterans endorsement interview for judicial candidates. On the onset, we would like to formally recognize and thank our sponsor organizations for making this event possible: Veterans in Politics International, Nevada Veterans Association, and the Armed Forces Chamber. We'd like to extend our sincere appreciation to sponsor community partners. Yeah, okay. We'd like to our sponsors give. It's my first time doing this. We would like to acknowledge our sponsors: Judge Jacob Reynolds, Department 29, Judge Mary Perry, Family Division, Department P. We're honored to have you here with us today. Before we begin the interviews, let's run over a few rules of format. First of all, the candidates will be given 1 minute to introduce themselves and state what they're why they're running. Each candidate, please include the office you are running for and explain why you're seeking the position. We will interview during the interview portion. Please remember that this is an interview; it's not a debate. We're not going against each other, and we'd ask you to answer the questions best of your ability. In the interest of fairness and participation, we strictly enforce the time limit would be 1 minute. So I'll be the timekeeper. You get 1 minute and 30 seconds to answer the questions. When I put my hand up, it'll be 30 seconds. When I close my fist, it'll be 10 seconds. Okay. Okay. There will be no follow-up questions. All the panel members will be completed. After complete their questions, we'll give you a 1 minute closing statement. Basically, talk about the first statement, and that'll pretty much be it. So we'll start with the interviews. The panel introduce themselves. We'll start with
Sue Christensen, Nevada Veterans Association.
Leslie Caliano, Veterans in Politics.
J.P. Edwards, Armed Forces Chamber.
Gary Jacobs, Armed Forces Chamber.
Cindy Lake, Veterans in Politics.
Let's see. Let's do Ms. Marr. Just introduce yourself and why you're running, what position you're running for, and why you're running.
I am Patricia Marr, and I am running for Family Court, Department D. I have a wealth of experience in family court. I've been litigating family court cases since 2008. I have an expansive history of litigating in civil court, in bankruptcy court, in criminal court, and appellate courts. And I believe that my vast diversity of experience and knowledge makes me an excellent candidate. I am running because, as I said, I do appellate work, and I have seen how decisions can adversely affect a litigant that does not have the financial means to appeal a decision if it's legally not correct.
Hi, good afternoon, everybody. I'm Gwynneth Smith. I am a Chief Deputy District Attorney here in Clark County in the Juvenile Division. So I have been practicing in the family courts in juvenile courts for over 12 years now. I'm in court 3 to 5 days a week. And so I always like to take the opportunity. I know when we think about family court, we think about divorce and custody, certainly, and that's a really big part of what family court does, a very important part. But our family court judges hear other dockets that are also really important. So 12 of the 26 family court judges actually hear other kinds of dockets. That's juvenile dependency, so cases involving foster care, juvenile delinquency, guardianships. And I'm running because, having been in these courtrooms for over 12 years, the decisions that our family court judges make and the cases that come in front of our family court judges, I will tell you, in my opinion, are some of the most important cases and legal decisions in our community. And we really need the very best, most experienced, most caring people on our family court bench. The other thing I will mention, and another thing that has led me to run, I have a pretty unique history. In addition to being an attorney, I'm also a psychologist. I trained as a clinical psychologist before I joined the DA's office. And issues related to mental health for kids and for parents and for the highly emotional cases that come in front of family court judges, having that background and that empathy, I think is key. So that's what led me to decide to run this cycle. And I'm running as well for Department D.
Thank you very much, Ms. Smith. Okay, we'll start the questions on the right side with Ms. Christian.
In a domestic violence case, when someone comes in and requests a restraining order in a domestic violence case, and then you later find out that there were false allegations basically to gain custody, how would you handle that?
For both of you. Go ahead.
In my practice, as I said, I practice not only in family court dealing with divorces and custody, but all other aspects, including TPOs, abuse and neglect, juvenile, and pretty much everything that encompasses family court. And unfortunately, lately, I have seen, thank goodness we have some great TPO hearing masters, but I have seen that if I am elected and I preside over a case, that's certainly going to be taken into account regarding a litigant's credibility and whether it's very unique in family court because you always have to consider the best interest of the child. And unfortunately, I have seen cases where it's clear cut. The judges even said that it's clear cut, be it false TPO allegations or allegations of being sexually inappropriate. But that has to be taken against the best interest of the child, and will ripping a child away from that parent truly serve in that child's best interest? So it's a very tough balancing act, but it's something that should be recognized. And also, the thing that is most upsetting is it takes away from resources of children that really need it. Sorry.
Same question for me?
Yes.
So I'm glad you're bringing up that issue because I think the issue of domestic violence is one of the most important that come into our family courts. Most consequential, right? Sometimes there can be deadly consequences if you don't get the decision right. On the other hand, you raise the issue of the consequences and credibility if an allegation turns out not to be true and the consequences for the person on the other side. It's really important from a legal perspective because both under child welfare laws and in custody laws, there's specific statutes with relation to domestic violence that if there's a finding, the court there's a presumption that they can't place the child with that parent. And that's incredibly serious. That creates a real barrier for a parent if an allegation is false. So truly one of the most important roles of a family court judge when a family comes into a courtroom is giving everybody the opportunity to be heard and to present their best case. And I think when we think about our family courts right now, it's such a high volume court. I know that, there's discussion about that. And so there can be a tendency sometimes in an effort to be efficient, which is important, that people may leave the courtroom and feel like they weren't heard, feel like they didn't have the opportunity to convey what they felt was important to the judge. And so one of the things that is at the forefront of my mind, the kind of judge that I will be, is the emphasis on making sure that every single person in my courtroom, no matter where you come from, what your background is, whether you have an attorney or don't have an attorney, you will get the time in my courtroom to express to me what you believe I need to know to make the best informed decision. Judges can only make the best decisions based on the information that they get. And so we have to be really conscious of that when we're on the bench, making sure that people know they're heard.
My turn. Okay, sorry about that.
So before we go, since my timer has an alarm, I'm just gonna hit the timer, and when the alarm goes, then
Okay.
I don't like to keep doing all this the way we
Okay, Patricia first.
How do your personal values guide your decisions, and what ethical principles are most important to you? Can you also ensure integrity and fairness in emotionally charged cases?
Absolutely, to the latter part of your question. I relocated from Youngstown, Ohio to Nevada in 1985, and I have made the Las Vegas my home ever since, and I've watched it grow, and I've seen the challenges that it's had since that time, particularly in family court. As Gwynneth stated, we have the judges right now hear quite a few cases, and it's important to get the decisions right in the limited time that the litigants are before you. Being from the Midwest, I had instilled in me a sense of integrity, responsibility, hard work, and that's carried through me my entire life. Nothing's changed that, and I think that that's critical when you're sitting on the bench, because you are affecting people's lives, whether it's where's my child going to sleep on Tuesday? Am I going to be able to pick my child up on Friday? Do I have to get daycare? It's important, and a lot of lawyers will avoid family court, and they think, they have their thoughts on what transpires there, but nothing could be more important than getting it right the first time. And I intend to just carry on with who I am as a lawyer and an advocate, bring that to the bench.
So I think your question about integrity is critical. It maybe will be the most important question today, because I think it's at the heart of what a judge does. It's at the heart of what a judge does because not only for the case that's in front of the judge and the parties that are in front of the judge, but also, and I think kind of equally importantly, the public has to have confidence in the integrity of the courts and the integrity of judges for the system to function. And so if a judge acts without integrity, it affects the functioning of the whole system, and the public loses faith in the system. And so I take that incredibly seriously. I am a mom. I am a wife. I bring that with me to the job that I do every day. I went into juvenile law because I know that the decisions that we make for kids and families when they're young carry through for the rest of people's lives. And that applies whether it's a divorce custody case or a child welfare case or a juvenile delinquency case. Family court judges decide such important issues for our community. And there's a lot of focus in judicial races, I think, and rightfully so, on the criminal courts and on the civil courts, and sometimes I think less focus on family court. And so I'm glad that we're here with you today and you're asking these questions focused on family court, because I think that it is so important. The last thing I'll say is, I joined the DA's office, and I worked as a therapist and a psychologist before that in hospitals with kids and families, because a big part of my professional identity is public service. And so that's what I would also intend to carry through as a judge. I think judges are first and foremost public servants for our community, and so I'll continue to do that.
Gary Jacobs, Armed Forces Chamber. This is a question for both of you guys. What are the statutory factors a judge must consider under NRS 125C in determining the best interest of a child?
One of the factors under the statute that I believe is most important, and there's a litany of them, is which parent is more likely to facilitate a relationship with a non-custodial parent. It's way too often that we see children being used as pawns and treated like chattel. And as Gwynneth said, it will affect these children as young adults and the relationships that they have later on in life. Factor A is whether the children or child is mature enough to voice a preference as to where they want to be. And while that's a factor, obviously not for young children, even for when children are older, it gives the children a voice to be heard, but it's not the end all be all, because think about what kind of world we would live in if teenagers were allowed to live wherever they wanted. I'm not doing the dishes over mom's. I want to live with dad. And obviously domestic violence, whether the child has ever been neglected or kidnapped. Unfortunately, I have seen, as I said, I've been practicing exclusively for the most part in family law since 2008. I've litigated countless custody cases, and I'm not going to get to the rest of the factors, but in my mind, those are the most critical factors. And there are, I don't know if I can continue, there are rebuttable presumptions, like with the DV, there's a rebuttable presumption, but it's important that we recognize that it's not just family court. These are people's lives. And I am also, I think I'm exceeding my time, but I'm also a mother. I've been through the system personally. I'm divorced. I've been a single parent. And so I know the challenges both in private life and in personal life, or professional rather.
Yes, so 125C, those best interest factors are kind of at like the heart of every case. That's the kind of North Star in custody cases, in child welfare cases, and juvenile law. As Ms. Marr said, there's many factors. I think there might be in excess of like 15 or 20. And that kind of illustrates the complexity of family court cases when they come before a judge. All those factors need to be considered and weighed by the court. Some of them are factors that focus on the child, the age of the child, the needs of the child, the developmental needs of the child. Some of them are factors that focus on the parent and their functioning, whether there's any issues related to substance abuse or domestic violence in that presumption. The age of the child, to what degree do they get to weigh in? And whenever I look at that statute and kind of consider all those factors, it just really brings home to me the complexity and the gravity of these decisions that a family court judge has to look at. There's so many things that the court needs to weigh. There's so many things that the court needs the necessary information from the parties to be able to convey to the judge so the judge can make the best decision for that family. And so it goes back a little bit to what I said before with the demeanor of the judge and the judge's ability to make people, I think, feel comfortable enough and heard enough that they're conveying to the court the important information so the judge can make a thorough analysis.
I have so many questions, and I didn't test my mic, did I?
Yeah.
Check it out. Okay. Check it out.
Hello? Can you hear me? That's why it was on the floor. Sorry about that. Okay, so I was really intrigued with your background, Gwynneth, but this is for both of you, and I'm intrigued with yours as well. I'm glad to know that you both have children, because I think it's crucial to be able to rule where it comes to children. And if you're not a parent, how would you, it's a little different. But okay, so your background in mental health and your background in psychology. I read a statistic last night that foster youth are disproportionately medicated 3 to 11 times more so than children who aren't in foster care. Is that something that concerns you as a person, as a mother, as a lawyer, as in the DA's office, and seeing what's going on with the drugging of children in general? children in general, or I guess the number is 5%, and we're talking about Ritalin, Adderall for ADHD, et cetera. Does it concern you as somebody who's about to be elected to rule and maybe even possibly change this statistic? And I really wanted to know, do you work closely with psychiatrists through the DA's office? Is it always they go right to a psychiatrist, or do they go to a psychologist? Are they always medicated in this case? Thank you.
It's a really good question. It might be more than a 60-second question, but I'm going to do my best. So you raise a really important issue, and it's an important issue for kids in foster care, but you're also right, it's an important issue for kids across the community, right? What are the first services that we look to when a child is in emotional distress or presenting with behaviors that are a problem? Do you turn to medication first? I'm trained as a psychologist, so I've never written a prescription, and that was not what I did. But I have worked with psychiatrists, and I do work closely with psychiatrists on some of my cases now. And with children, you have to be incredibly conservative and incredibly careful with the use of medication. I'm not going to say that it's never appropriate, but you have to be very conservative with it and very focused on how it's affecting the child, and also focused on what other services might be beneficial first. And so as a psychologist, I can tell you what I did, and I practiced for almost 5 years before I joined the DA's office. Over the course of my training, I was a therapist, and I specialized working with kids and families who had experienced significant trauma. So kids who were in the child welfare system, parents who had kids in the child welfare system, as well as victims of sexual assault. And to me, therapy and the development of that therapeutic relationship is so important and very effective. So I am a big advocate of looking at all of the options that are out there, consulting the experts, but making sure you're being very thoughtful with children, particularly kids who are in the system.
Thank you. Like Gwynneth, I have a background, I have a bachelor's in psychology. The role on the bench, however, maybe I should answer the latter part of that question. As a parent, absolutely, it's concerning that children are being medicated to that extent that you just stated, and those statistics are alarming, to be quite frank. On the bench, however, when you preside over a divorce or a custody case, that's far different than what Gwynneth has been doing as her role, prosecutor's role. With that being said, we have joint legal custody, and I've seen very few cases where parents don't share joint legal custody. And with that joint legal custody comes shared decision-making regarding religion, medical, education, extracurricular activities. And so for the judge to step in and make a decision that is in the parent's role, I think would be overstepping the boundaries unless you have a unique situation before you where you might say, this child appears to be, the parents' efforts are failing, maybe have the child evaluated. But I don't think it's appropriate for the court to step into the role of the parents because presumably and hopefully they know best for their child. But again, that is a shocking number that you just stated.
Sue Christensen, Nevada Veterans Association. Family law is one of the areas of law that doesn't have a lot of case law. A lot of it's up to the judge's discretion. If you make a decision about custody, whether it's 50-50, 60-40, whatever it is, and in the 15 minutes that this case is in front of you, because we know they're herded in there like cattle, unfortunately, and your decision is wrong, and the next time they come in, are you the type of people that are willing to reverse your decision, or are you going to stick by that because that's the decision you made and you don't want to be wrong on the bench, or are you going to at that point do what's right for the child? And that's for both of you.
That is a great question, and I believe that it's akin to somebody filing a motion for reconsideration. And absolutely, I would be intellectually honest and say, you know what, I was wrong. I was wrong, but I did the best with what I had before me at the time. And you are correct that hearings need to move quickly because unfortunately there are a lot of people down in family court and it's never a good, nobody ever wants to be there. But with that being said, I believe that I am particularly sensitive to that because in my almost 20 years of practice in family court, I have seen where either a litigant will commit suicide or a child comes back in a casket. And so I take this proposed role very serious. I lost a son at a very young age, and so I'm aware, and that awareness is even heightened by my professional career where I've seen it happen, and it should never happen. So that's why it is so incredibly important to get it right. And I don't know if I have any more time left.
You finished under time.
Oh, okay. I'll take a perfect score then.
Your question's a really important one. I think two of the most important qualities of a judge, maybe most important qualities of human beings in general, is humility and the ability and willingness to work hard. I think if you have those two things, you can come to do a good job at most things, and that includes being a judge. Those are two of the key things. So part of your question was about, this limited time for hearings, and that's true. And I do think that people leave the courtroom because of the volume of cases and feel like they weren't heard or didn't get the opportunity to say what they thought was important, or that they felt they left and they may not even understand the totality of what had happened. So the first thing a judge needs to do, judges need to be super prepared, and judges need to be doing a lot of work outside the courtroom so that by the time that hearing time comes, that will not be the first 15 minutes I have spent on your case. I will have reviewed everything that's been filed. I will have reviewed the history of the case, and, the litigants in front of me will know that. I will reflect that I know the case. And then also, in terms of having humility, I think being a judge, it's important to set your ego aside, and you're there because people need assistance with critical issues. And so if a family comes back and there is new information or something that was missed that needs to be changed because it's the right decision for that child or family, it's not about the judge and their ego, it's about making the right decision.
Leslie Caliano, Veterans in Politics. So I'm going to lighten it up a little bit. What clubs or organizations do you have or belong to outside of your career?
That's a great question. Right now, I'm a sole practitioner. And so being a sole practitioner, you're faced with many challenges. And to be quite honest with you, my work comes first, and it leaves very little time for me personally. With that being said, I do like to travel. I sit on my HOA board. But aside from that, I am joining a pickleball club. This year, I made a decision, but when, if somebody calls me or texts me and they have an issue, a client, they come first. So I have to start doing a better job with my personal life because to be quite honest with you, I love my job. And I had my daughter asked me, she said, Mom, I just don't know how you do it because she sees what how my day runs. And I told her, and I hope she's listening, that you have to love your job and you have to be passionate about it because you're going to be doing that for the bulk of your day. So you better really love it. And I hope she hears that again.
So like Miss Marr, I do a lot of working in my life. So that's a big focus of mine. When I'm at my job and I'm working 100%. I do try and balance that with things outside though, just because I think it helps me as a human being and I end up A, being happier and B, I do my job better when I'm there by balancing it with other stuff. So I have an 11-year-old, so she keeps me very busy. I try and spend as much time as I can with her when I'm not working, with my husband as well. My mom lives with us, and so spending time with my mom is really important to me. And then kind of community, giving back to the community. I'm on the board of directors of an organization called NAMI of Southern Nevada. I don't know if any of you have heard of NAMI. It stands for National Alliance on Mental Illness. It's the biggest grassroots organization nationwide, actually, providing services and advocacy for people with mental health challenges. And it does really important work because it kind of fills the gap. It's difficult to access services in our community, right? It's difficult to get into a therapist. It's expensive. You maybe see that person every couple weeks or a month. One of the focuses that NAMI has is peer support and family support for families that are helping a family member with significant mental illness. And so we provide that throughout the community. I've done that for 5 years and I love it.
Hello. Gary Jacobs, Armed Forces Chamber. This is for both of you guys. Tell us about a legal position you once strongly held that changed after and what caused the shift.
That is a great question. I worked for a sole practitioner in 2008, and that's where I began to do family law. And I just recall he was my mentor and he taught me so much. And I was very upset. As I said, my passion remains as it was in 2008. And I was very upset about a decision that a judge had made on the case. And we spoke about it in depth. And he said, Patty, perhaps the judge is giving the other side enough rope to hang themselves. And so that did change my position. I thought, oh, okay, that's okay, thanks. But I think, and this kind of relates to the question asked previously, if learning later on that a decision maybe was in the best interest of the child when you didn't think it was. I mean, the complexity and the dynamics of the relationships are so extensive in family court cases. I'm not adverse to changing my mind or my position. If you have to set aside your humility and do what's right. And you know what? When I get home every night, I have no problem looking at myself in the mirror, and with performing the work that I've performed.
So one of kind of the things I love about juvenile law and working with kids and families, it's one of the reasons I started downtown in criminal court and then actually requested to come to juvenile court. I wanted to work with kids and families at the DA's office. And I did that because these cases are unique. These cases aren't like a zero-sum game where someone has to lose and someone has to win. These are cases where, if possible, you want to craft a solution that as best as possible works for everyone involved. And so one of the things I always do as a DA, if we have a case that comes in as a child welfare case, and we have a child who might be in an unsafe situation. But we also have parents who, I think when parents come in on child welfare cases, it's one of the most frightening things that can happen to you as a parent. They may need help with some really significant things, right? Whether that's mental health or whether there's a substance use problem. And so I always, with their counsel, of course, I would never talk to a parent as the DA by myself, but I try and sit down with them and their attorney and talk about what's actually going on as humans and what is going on in their lives. What do they think they need? What do they think would help them and their family? What can the court offer? And so I wouldn't say those experiences like change a legal position for me, but I certainly have changed the way I've thought about cases by sitting down with the actual families involved and learning their perspectives. And then that influences what I think we need to put in place going forward. And you have to be open-minded like that as a judge.
Cindy Lake. Is this working? Yes.
Yes.
Cindy Lake, Veterans in Politics. Okay, so I'm going to append the last question to the last question because I too have lost a son. I'm very sorry for your loss. So this is where my passion comes from, as far as the drugging of our children, et cetera. So you had mentioned, Ms. Marr, that you've seen children come back in caskets and suicidal and homicidal ideation, and domestic violence is such a huge problem in our community, right? But how much do we put into knowing whether the parents are on psychotropic drugs and possibly encountering side effects and then committing acts of domestic violence? Is there enough time to even delve into this, or how much can we, in a 15-minute court case, know all of that background? And again, I'm asking, would you want to change anything from what you've seen as an attorney and in your capacity? Thank you.
That is a fabulous question. And with that being said, there seems to be a misnomer that a judge only sees a case for 15 minutes. That may be the average, but I've seen judges, and I'm always appreciative when they take longer. And I believe you're limited to the pleadings and the litigants that are before you. But that's where experience comes in, and being able to assess, being able to issue spot. I've been in a different role than Gwynneth, because I've been involved, haven't worked for the DA's office, but working in custody and divorce cases, it's like you're working against the other parent, so to speak. A lot of times they're emotional and they believe it's like winning. Oh, we have to win. Nobody wins in family court, because you're there to begin with. But with that being said, you have to, I don't want to talk about my cases, but I have seen the other parent commit suicide when they've been denied custody. So again, you cannot take these matters lightly. You can never be jaded. But as a judge presiding over those cases, you can't sit down with the parents. Perhaps you can refer them to a settlement conference or mediation or a child interview. There are a gamut of things, tools that you have as a judge that you can use. And I'm always open to change. I know some of our judges have implemented programs for people that can't afford attorneys, and I think we continue to progress as a judiciary.
So I think another thing that a judge can do and is really obligated to do with people in their courtroom, because you're right, the docket is so crowded and the feeling that people don't get the time that they need in front of the judge. So number one, it's the kind of DA I am and it's the kind of judge I'll be. I take every single case in front of me, knowing that there are children and parents and actual human beings behind that case, and that obligates me to take the time and attention and diligence with every single case. That starts before the case is ever even called. So you have a responsibility as a family court judge, because the records of family court cases, it's not just a single issue and then the case goes away. You may have years of history in the system. You need to be familiar with that history. Then, when you get to the hearing, if there's an issue that has come up that necessitates additional time by the court, then it necessitates additional time by the court, right? Because the decisions that are being made, as you've said, are so consequential. These can sometimes be life or death decisions. And even if it's not a life or death decision, it's a decision that's going to affect this family forever. So you have to take the time that is necessary for that family. The other thing I will say, and I'll be super quick, is the demeanor and temperament of the judge is so important. And I think that helps people be able to have a comfort level and be able to express themselves in a way that gets the information that they believe is important across. And so that's something that I have always brought to the work I do as a DA. It's the kind of judge I would be. You don't give legal advice, but you can slow the process down. You can explain what's happening. You can explain the resources that are available. You can convey that you're listening so that people know that what they're telling the judge is important.
Okay, we're going to give each candidate 1 minute to reiterate why, what position they're going for and why we should elect them.
I am running for the bench for Family Court Department D. I believe that my wealth of experience and my diverse experience makes me suitable to preside over family court cases. Department D is going to preside over divorce matters and custody matters, and I have performed countless trials in that regard. And so I am very aware of the nuances that are essential to providing a family with the best possible result that they can have moving forward. I remain passionate as an advocate, and I will remain passionate as a judge to make sure that people have been heard, that they believe that they've been treated fairly, that children remain safe, and that people, as I said again, can move on with your life. Life is short.
Thank you. So again, I'm Gwynneth Smith. I'm running for Family Court Department D. As I said at the outset, I've decided to run for family court judge because having been in the family courts now for over 12 years, I see every day how important and consequential these decisions are. I take that incredibly seriously, and I think we need our very best people on the bench in family court, and so that is why I'm running. I'm also running because I know that I bring a truly unique background and perspective to this, having been a psychologist for kids and families, as well as an attorney, and bringing that now to the bench. We see so many issues related to mental health of kids, mental health of parents. The issue of medication has been brought up. That comes up in these cases. Substance use, all of these things that I have worked directly with families on. I see the faces of former clients when I think about these issues, and I know the consequences of the decisions that are made in the courtroom that then reverberate outside the courtroom for a lifetime. So I am ready to work hard. I am ready to be a public servant, continue being a public servant. And I'm just very grateful for the opportunity today and the questions. Thank you.
Thank you to the panel. Thank you for the candidates. Before we leave, again, we want to thank Judge Mary Perry, Family Division, Department P, and Judge Jacob Reynolds, District Court 29. And this concludes our joint endorsement interviews for this session. Thank you very much.